Silberman. My colleagues have heard me talk about the new TILA RESPA forms. You're certainly aware that the real estate industry and real estate closing industry is focused on this. One would expect some bumps in the road once these rules become effective. Have you explored the idea of a reduction for a few months or suspension of the penalties for the innocent errors that are likely to be made in the first few months of operation?
Well, thank you, Congressman. The TILA RESPA rules, the know before you owe rules, as we think about them, as you know, were issued in November of 2013. We did provide for a very long implementation period in order to assure that they could be effectively implemented. We've been working diligently with the industry to assure that it can get implemented effectively. I believe this Director Cordray spoke to this issue when he was before the full committee last month and has some recent correspondence. And I think what he said is that we are focused right now on assuring a successful achievement of the effective date, but that we always and continue to listen to people's ideas around that.
Well, I hope you'll listen to the idea that, yeah, you have an effective date, but it ought to be a soft date when it comes to be either imposing governmental penalties or opening the door to civil lawsuits, because until you take it on a shakedown cruise, you don't know which part needs to be fixed. Mr. Fazio had this great question about the need for supplemental capital, but somebody else already asked a similar question. So instead, we'll talk to you about how NCUA has not shown any instance where the lack of enforcement authority over credit union service organizations has been a material issue. Is it correct that NCUA already has authority via the credit unions they regulate to review and dictate enforcement with regard to credit union service organizations, which insiders call QSO? I was told to mention that to show that I really knew the industry. It's my understanding that non-QSO vendors are already subject to reporting and reviewed through the Federal Financial Institution Examination Council. With the tight budgets that everyone in government faces, do you really need to get involved in this in a new way?
So thank you for that question, Congressman. Two aspects to that. I'll take the latter first. The non-QSO vendors, third-party vendors that are not our credit union service organization, if they do business with banks, then they would be subject to oversight by the other FFIC agencies. However, we have several vendors that are large that only serve credit unions as clients, and they're not QSOs, and so they're not subject to regulatory oversight. There's a blind spot there, and we've in fact had problems with a few of those historically. In terms of QSOs, in particular, to the former part of your question. We have had, in fact, some problems with QSOs. We have an indirect authority over QSOs. We have a regulation that requires credit unions that do business with QSOs or that own a QSO to require certain things contractually, like access to books and records, that they follow generally accepted accounting principles in preparing their financial statements and so forth. However, it's a very indirect authority in that sense. We don't have insight into the full landscape of the credit union service organizations. And our limit to their books, and we have limits in how we can access and examine them in terms of understanding their business models. We've seen problems historically in QSOs, and I would say that QSOs are a great opportunity for especially smaller credit unions to collaborate. We support that, achieve economies of scale, and do things they might not be able to do otherwise independently. But it also creates a gap in our ability to understand the nature of the risks to those credit unions. In some cases, dozens.
I'd ask you at least not to duplicate the efforts of the Federal Financial Institutions Examination Council,
we would have no intent of doing so. We cooperate and collaborate with them closely.
I've got 14 seconds, so I'll just point out that the gentleman from Florida, Mr. Posey, and I have a great bill that perhaps if the FDIC would focus on it You could solve it at your level. You've got bank holding companies where you would not have an invasion of the assets of the insurance company that they might hold. Should there be a liquidation, you need to do the same for thrift holding companies, because we've got a state system of regulating insurance companies, and the assets of the insurance company need to be there to protect the policyholder and shouldn't be rated by the FDIC for other purposes. I'll yield back.
I thank the gentleman, and now the gentleman